Hey everybody. Can you hear me? Can you hear me? Can you hear me? All right. So we need to talk some more again tonight. And so if you guys can share, it would be great. Let's see if we can get a few people out and online. You guys can all hear me, right? Everybody hear me? Okay. I'm going to assume that you can. My name is Tanner Downing, and I'm civil rights advocate litigator. I think you guys already know what I do and who I am, but for those of you who may not know, who may just be joining, we're in active litigation against this corrupt government, and so we got a big problem because we got an awful lot of states right now that are not following the rules. They're not following the laws that grant them their office and grant them their authority, create their office. And we need to get this addressed because the only thing that makes America is, okay, let's see here. 1 second here, guys. Okay, so so right now we have 33 states that are refusing to enforce and recognize the body laws governing the nation. That's a big deal. That's a big problem. Okay, so what we've done so far is we provided notice to the top executive officer in those 33 states, to the Attorney General. All right, and we gave them an opportunity to be able to respond to the allegations. And when they failed to respond as lawfully required, then that means that all of their agents are now implicated in it, because notice to principal or notice to agent is notice to principal, and notice to principal is notice to agent. These attorney generals, they had a responsibility and a duty that if their agents are committing crimes and we identify the criminal acts that are being committed, then they have a duty and obligation to take action to correct the unlawful and criminal behavior of their agents. And when they fail to do so, then they're now implicated in it. So, the laws of criminal conspiracy state that any person who, having knowledge of any of the wrongs conspired to be done and who have the power to prevent or aid in the prevention of the commission of same, neglects or refuses to do so, may be joined and suspends the action. So, we wanted to give them an opportunity to be able to do the right thing and to hopefully correct their behavior. They didn't do it. And so then I returned and we provided service on the same 33 states Supreme Courts because that's the top judicial officer. So now we've notified the top judicial officer, and now they had a duty and obligation to take action to correct the unlawful criminal actions of their agents. They failed to take action as well. So then I went to D.C. and we provided the same notice to the legislators. They're the top legislative officers, the senators, the congressmen. We went in and I informed all of their agents of the same criminal behavior that's being conducted. Gave them an opportunity to be able to take action. They failed to take action. So now we have every single political official within all 33 of those states. They're now implicated in this criminal conspiracy. And let me lay it out for you, okay? Now, I'm going to get away from the indictment issue in just one moment because I want to explain, exactly what we're doing, because this was always about the family. From the very beginning, this was about the family, and I'm going to tell you guys now, I'm going to let you in on the secret now as to why this is all about the family, okay? But here's the scenario. This is what gets us into the court. This is what gets us heard, is that when Clause 1 of Amendment 5 to the United States Constitution, I think we would all agree that that's part of the Constitution because it was ratified by the people on December 15th, 1791, and according to the special amending procedure, once ratified, proposed amendments become part of the Constitution in all intents and purposes. So it's clearly part of the Constitution. But what Clause 1 of Amendment 5 says is it says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. So that's clear. You must have an indictment by a grand jury before arresting someone and holding them over for a capital or an infamous crime. Now, we all know what a capital crime is, right? That's a crime that results in death, punishable by death. But an infamous crime is defined as any crime punishable by more than 1 year imprisonment in a penitentiary. So if you can get 1 year, more than 1 year, then that would be an infamous crime. Now, United States versus Coachman, Supreme Court of the United States, they said that it's not the amount of time that you get sentenced to, but the amount of time you can be sentenced to. Therefore, most gross misdemeanors are also infamous crimes because you can get more than 1 year. Just because you only get sentenced to 3 months doesn't not make it infamous. The infamous nature derives from the amount of time that you can be sentenced to, okay? So if you can get more than 1 year, according to the Constitution of the United States, you must have an indictment by a grand jury before holding someone over for an infamous crime. In other words, before arresting them and holding them over for that trial. Okay? But we have a number of states that have decided that they're not going to follow those very, very simple procedures. It's a very, very simple procedure, and they charge by what is known as information, right? Now, information, according to Title 18, subsection 555, can only be used as a charging instrument for non-infamous crimes, for misdemeanors. Now, what happens with information is this, is that someone will call up the police and they'll say, yep, something happened to me. And the police will take that information from the accuser, they will reduce it to writing in the form of an affidavit, and then they will submit it to the court asking for the arrest and everything else, right? But the problem is that the Fourth Amendment says that no warrant shall be issued but upon probable cause supported by oath or affirmation. When information is taken by the accuser and the officer presents that information under his own oath, that becomes a violation of the Fourth Amendment, because guess what? That officer wasn't a witness to it. He's not the one that should be taking the oath. The one that should be taking the oath would be the person that's accusing of the crime, the actual witness. And the actual witness does not ever submit that information. So as a result, who becomes your accuser? Well, none other than the officer who received the information and reduced it to writing in the form of an affidavit and said, well, this is factually true, correct. And now we have someone that wasn't even a witness that's saying, yeah, this is all factual, true. We don't know if that's factual because you weren't a witness officer, right? And so what happens, unfortunately, with information is that it's submitted to the court, and then that officer, and then the judicial officer, what he does is he says, well, I'm going to determine whether or not there's sufficient probable cause to assume the crime has been committed. That's the purpose of the grand jury, is a neutral, unbiased third party to review the state's accusations to determine whether or not there is probable cause to assume the crime has been committed. So, but unfortunately, that judge, that prosecutor, that officer, they all work for the same body of men, the state. So the state has become your accuser, and as a result, that judge has a conflict of interest. He works for the plaintiff. He has a duty and responsibility to recuse himself. Now, if you guys were to go to Title 28, subsection 455, which is the automatic recusal for judicial officers, if you were to read it, what it says is that judges have a duty to recuse themselves, and this is a self-executing duty, meaning that you don't have to tell him to recuse himself. He has a self-executing duty. He must recuse himself, and it's non-waivable, it's non-discretionary, and it's a mandatory self-executing duty if he is an officer of either party. Now remember, these are judicial officers of the state, so clearly they had a responsibility and a duty to recuse themselves, because the Constitution of the United States says that you can't be both party and judge in the same cause, right? That's Article 3. So this is a very, very simple concept. But what happens with information is that once it's reduced to writing and it's submitted to the court, right, you are being arrested, right, because you're presumed that you're guilty, because someone said that you did something. You don't get an opportunity to be able to confront those accusations. You don't get an opportunity to be able to go in front of a neutral, unbiased third-party decision maker to be able to confront those hearsay evidence that's against you. No, you're treated as though you're guilty because someone else said that you did something, and yet you've never been given a due process or an opportunity to be able to confront that accusation against you. This is what's called an irrebuttable presumption of guilt. It's an irrebuttable presumption of guilt because you've never had the opportunity to rebut the accusation against you. That's the purpose of the grand jury. You know, the purpose of the grand jury is to protect the innocent, from hasty malicious charges. And unfortunately, what happens is that the innocent doesn't have an opportunity to be able to be presumed to be innocent. You know, if the guilty have rights, what about the innocent? Where are their rights? Because you don't get an opportunity to be able to be treated as though you're innocent when you're arrested, put into jail, thrown in, and presumed to be guilty. So in an irrefutable presumption of guilt, what happens is again, you are presumed guilty based upon the mere fact of being charged with the crime. That is what an irrebuttable presumption of guilt is, okay? And what happens specifically in that is that the burden of proof shifts. Ordinarily, the prosecutor must prove that you're guilty beyond reasonable doubt, right? That's what we all believe. That's what we're all told. That's what everybody, out in America believes, is that you're innocent until proven guilty, right? But not if it's an irrebuttable presumption of guilt. If it's an irrebuttable presumption of guilt, you are presumed guilty based upon the mere fact of being charged with the crime. You're being deprived of your liberty. You're being deprived of your ability to be able to go and earn money and take care of your family, to own property, to use your property. All of these things that you have the right to have are all being taken away without due process because the system assumes that you're guilty based upon the fact of being simply charged with a crime. All right? Well, this shift in the burden of proof means that the prosecutor no longer has to prove that you're guilty. Now you have to go collect evidence to prove that you're innocent, which is a complete shift in our legal philosophy. You are supposed to be innocent until proven guilty. But if you're being treated as though you're innocent, then why aren't you being given the opportunity to be able to confront the accusations against you? That doesn't seem to me like you're being presumed to be innocent, right? If you're being arrested simply because someone else said that you did something, and you're now being deprived of your liberty and all these other things, your property and whatever else, you're not being treated as though you're innocent. Where is the presumption of innocence? It goes away with information, right? It goes away because the prosecutor says, you know what? I'm going to take a side in this, and I'm going to take the side of the accuser. I'm going to represent the accuser, and now the state has taken a side against you, and they've accepted only one side of the story, and they don't want your side to be told, which is why they work so hard to get you to plead guilty, because they know that whatever you got to say is going to be detrimental to their case, right? They don't want it to come forward. This is the danger of information. But according to Blackstone, this shift in the burden of proof, it occurs. And Blackstone even wrote about it. You guys can read about it. It's in Black's Law Dictionary. Blackstone said that this particular issue, this shift in the burden of proof, that it occurs anytime that there is, that the system focuses on speed and efficiency as opposed to established procedures and processes. Right? We have a government of laws. It's established based upon law, and we need to follow those laws because those laws provide procedures for the protection of the innocent. So we can preserve the individual rights that every single person has by limiting the powers of government, right? That's the purpose of our Constitution. So what happens then is that the system says, you know what? There's too many people. If we don't do it this way, if we don't force people into pleading guilty, if we don't threaten and intimidate them and force them into these contracts illegally, then look at all the people that would get away, or it would clog up the system, or they have all kinds of excuses to justify their illegal behavior. But at the end of the day, it still is illegal behavior because the Constitution clearly states that you got to have an indictment by a grand jury. And if you don't, then guess what? You just broke the Constitution. You just broke the law. And by the breaking of the law, guess what? It doesn't matter what you do. It is all unconstitutional because it all derives from an unconstitutional act. It's as simple as that, you guys. This is not a difficult concept to understand. That's the reason why government is silent on this issue. That's why no one will come out and debate me on this issue, is because they know that they're going to lose. They know it. And I know that they're going to lose too. This is not even an issue. It's not even a question. Because anytime that government chooses to not follow the rules, if they breach the Constitution, what they produce is unconstitutional. There is no justification for it. There's no buts about it. It's a crime, what they're doing. So what happened, all right, what happened is that in 1833, the United States Supreme Court, they came out in a case called Barron versus Baltimore, the highest court in the land, and they said, you know what? We don't have to follow the Constitution. We don't have to give the Bill of Rights to the people because that's only a restriction against the federal government. It's not a restriction against the state government. Well, that's a bullshit ruling, but they made that ruling anyway. And as of that moment, no one had the right to an indictment by a grand jury. No one. And unfortunately, that is still standing Supreme Court precedent today. That's the reason why 33 states do not conduct a grand jury. That's the reason why you're not given the opportunity to be able to be present in the grand jury to confront the accusation against you in 99% of all grand jury proceedings. Doesn't mean that's lawful. It means that the highest court in the land has directed all the courts to act unconstitutionally, right? And because the highest court in the land directed every single court within the nation to act unconstitutionally, that means that everything that all these courts are producing is going to be unconstitutional, because just because the Supreme Court says you don't have to follow the Constitution doesn't give the rights to be able to the right for the states to be able to enact a law that's abridging the rights of the Constitution. So when the state of Washington said, oh, well, Supreme Court said we don't have to have an indictment by a grand jury, therefore we're going to create a provision in our inferior Constitution, Article 1, Section 26, that says no grand jury shall be drawn or summoned in any county. Well, guess what? That is an unconstitutional law. It doesn't matter what the Supreme Court of the United States says. They can direct you all they want, but you have a duty and obligation, just like constitutional law subsection 171 states, right? The federal courts and state courts have an equal obligation to guard and enforce every single right secured by and enumerated in the Constitution for the United States. So the state of Washington had no authority to be able to create a law by relying upon a judge-made ruling that's not law to violate and bridge the rights of the Constitution. They're codified and written right there. But when they relied upon a judicial ruling that the judges called law, and remember, judges can't create law, right? They can't create law. That's a separation of powers issue. You cannot legislate from the bench. Judges do not create law. They create rulings. So when the Supreme Court of the United States, when they chose to alter, amend, or destroy the provisions that guarantees the Constitution through judicial fiat, that would be an unconstitutional act. So my point is until the Supreme Court of the United States comes out and corrects the ruling and states, no, states, you must follow what the Constitution demands, then the highest court in the land is permitting and sanctioning the unconstitutional acts of every single court across the country. There isn't a single criminal judgment that's being conducted right now in any state, anywhere, that's lawful, because the highest court in the land has directed all of the courts to act unconstitutionally. This is the Supreme Court's fault. They made this mistake. They made this decision, and it was absolutely unconstitutional. It's not valid, because we can all read what Clause 1 of Amendment 5 says. It says you got to have an indictment by a grand jury. So where was the change? Because it wasn't done by the people. It wasn't done by an authentic act of the people in accordance with the special amending procedures of Article 5. So the question I have to all of you, or to 2.9 million people currently imprisoned across America today, where's your indictment by a grand jury? Why weren't you present in that grand jury to confront the accusation against you? Right? You see, there's two main issues here. The one is the facial constitutional violation, which is when a state doesn't do at all what they're supposed to do, right? Such as the state of Washington. When they say no grand jury shall be drawn or summoned in any county, then that means that the state of Washington has a facial violation of the Constitution. They don't conduct a grand jury. They don't issue indictments. They just proceed for everything under information, right? That would be a facial constitutional violation, because it's facially in direct violation of what the Constitution requires and demands, what it enumerates. And so that would be a facial constitutional violation. The other issue is the 99% of the other people who aren't present in the grand jury to confront the accusation against them. Because here's the thing, you guys. The purpose of the grand jury is to protect the accused, not to protect the accuser. It's a proceeding that's there for the protection of the accused, right? So when the state denies you the right to be present to confront those accusations against you, that is an abusive process. Because that's not there for the state's benefit. That's not there for the accuser's benefit. That is there for the accused benefit. It's for his protection, his right to be able to confront the accusations against him. But when the state says, well, you know what? The accused, we don't want them to win because we've taken a side against him. Therefore, we're going to prevent him from being able to be present to confront the accusation against him, because anything he's got to say is going to be detrimental to our case, right? Well, unfortunately, states cannot treat two people in like circumstances differently. You know, if you've got an accuser and you've got an accused, the purpose of the state is to arbitrate those two, to act in a neutral, unbiased manner, to rule both of them, right, in a fair manner. But when the state says, oh no, we're going to jump on this side, we're going to take this side here, we're going to listen to what they got to say, and we're going to deny this other side to speak at all, to present any of their evidence, we're just going to lock them up and assume that they're guilty. And well, unfortunately, you're treating two people in like circumstances differently. That would be a clear violation of the Equal Protection Clause. Clear violation. Government can't treat two people in like circumstances differently. But if you're being presumed to be innocent, then you should be there present to be able to confront those accusations against you. If you're not, that's charging by way of information. All right? So there's also a criminal element to this, okay? Yeah, they can't be party in their own proceedings. You're absolutely, that's the whole point here, is that the state cannot be both judge and party in the same cause. So when a state does enact its own alternative legislation and then substitutes it for the guarantees of the Constitution, that would be an unlawful act, right? Such as the state of Washington did in Article 1, Section 26. Article 1, Section 26, again, of Washington State's Constitution says no grand jury shall be drawn or summoned in any county. So the state of Washington created a provision in its inferior constitution that functioned directly to the contrary of the United States Constitution. That in and of itself is known as sedition, because sedition is defined as the speaking or writing of words, such as law established, in order to cause disaffection to the Constitution to procure its alteration in other than lawful manner. So if you choose to alter the Constitution in a manner other than what's prescribed within the special amending procedure of Article 5, that would be a seditious act done by traitors to the nation. But when the state did do that in 1874, 1875, whenever it was, when they did enact that provision in their inferior constitution, the seditious act occurred, right? They created an oppressive law because it treats people differently in like circumstances across the society. But when they directed their agents then, a prosecuting attorney, to charge by way of information, that prosecuting attorney has a duty and responsibility to make sure that they are able to fulfill the oath that they took. And the oath that they took was not to the state constitution, it was to the federal constitution. The reason why is because, yes, they did take an oath to both the United States Constitution and the state constitution. But the problem is that the state constitution, Article 1, Section 2 of the Washington State Constitution says the United States Constitution is the supreme law of the land. So the state constitution has already placed itself into a subjection into the United States Constitution, which means that it doesn't matter what the state constitution says. Your obligation is to that because the state constitution is in subjection to the federal constitution. And every other state has also done the same. So just because you take an oath to two different constitutions doesn't say, oh, I'm going to follow the state constitution, because the state constitutions have all subjected themselves to the supremacy of the United States Constitution. Therefore, it really doesn't matter what they say. What matters is what the United States Constitution says. So the prosecuting attorney has a duty and responsibility to protect and preserve every right. That's their obligation. That's the oath that they took, is to protect and preserve all the constitutional obligations for the people that are in the state or whatever. And so when they choose to rely upon the inferior state statute that deprives a person of right guaranteed by the Constitution of the United States, in doing so, they just committed a crime. It's deprivation of rights under color of law, Title 18, subsection 242. Now, what that statute says is it says any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any right secured by the Constitution, commits that crime. So you got to remember that 242 says that any person who, under the color of any state statute, ordinance, custom, regulation, who can actually operate under the color of law other than public officials. So Title 242 was written for public officials. That is the restraint for them. That law is created for them. It's not created for the people. That was created to restrain the government and to ensure that they're bound to guarantee and follow the rights that are enumerated within the Constitution of the United States. See, the history behind that, it goes back to 1958 Brown versus Board of Education. You see, what happened was that Plessy versus Ferguson was all about segregation in the South, right? It was all about separating and segregating the people. It was a decision that was made by the Waite Court. It was a terrible decision. It was absolutely unconstitutional, but it created divisiveness across the nation. It made the people pitted against each other, fighting against each other, because when you bring racism into the mix, then that causes the people to fight amongst each other, because the government wants that to happen, because as long as we're fighting amongst each other, we don't realize that it's the government that's the true antagonist, that they're robbing us blind, right? Because we're looking over here, we're fighting amongst each other, and we're not looking over here saying, oh, wait a second now, it's the government that's the problem, not us, right? But what happened was Plessy versus Ferguson, it allowed for the segregation in the South. It was successfully challenged in 1958 by the NAACP, and they got a technical overrule. Right, and so now we had to unify the nation. No longer segregation, no longer separate but equal. Now we're going to reunify. Well, the problem was that the South, they didn't want to reunify. The judges in Georgia, in Mississippi, in Alabama, they were refusing to reunify after the ruling came out. And so then what happened was that we had to create legislation in order to ensure that the segregation actually occurred. That's where the Civil Rights Act of 1964, the Civil Rights of 1968, that's where they all came into play. Was that we created this legislation to ensure that we had the enforceability of these judges in the states. That if the judges in the states said, oh, we're not going to do what the Supreme Court of the United States says we have to do, we're not going to do what the Constitution of the United States says we have to do, we're not going to do it because we don't like it, because we don't like the ruling, because we would prefer to have this, this segregation and all this. But they were refusing to reunify. And as a result, we created legislation, and it was the Title 42 legislation, right? So Title 42 is all about the Civil Rights Acts. This is the enforcement element of the Civil Rights Acts. And so Title 42, subsection 1981, for instance, or 1983, which would be your ability to sue for civil rights actions. 1981 is a great one because that says that all persons within the jurisdiction of the United States shall have fair and equal benefits of all laws and proceedings, right? So if you're within the United States of America, then you have full and equal access to all laws and all proceedings, which is very interesting because the Fifth Amendment is a law of the United States. Therefore, it is protected by 1981, is it not? Yeah. And then the grand jury is a proceeding created by the laws of the United States. Therefore, it is protected by 1981 as well. So if you are to have full and equal benefits of all laws and proceedings, then why are you not present in that grand jury, right? You have to have full and equal benefit of all laws and proceedings. So when the state denies you your right to be present, are you not being deprived the benefit of that proceeding? Absolutely you are. And now you have a crime that's been committed. You see, Title 42 in the Civil Rights Act, what it did is it created two different elements. It created an enforcement element and it created a civil element. So if your civil rights have been violated, you have the ability to sue now, those that have violated your rights. But before you can sue, you have to first look at the enforcement elements, right? Because your right to sue derives from a breach of someone's obligation. And a breach of obligation is also known as a crime, right? So the Title 18, which is the enforcement statutes that derive from the 42, the Equal Rights Statute, is Title 18, subsection 241, 242, 243, 244. These are the enforcement code that applies to the Civil Rights Act. So anybody that says to you that deprivation of rights under color of law doesn't apply to judges or prosecutors are either lying to you or they have no clue what they're talking about, because that statute was created for judges, for prosecutors, for law enforcement. That was the purpose of that statute being created. Those are the enforcement statutes for the Civil Rights Act. So in order to be able to enforce, in order to be able to sue for a violation of civil rights, you must first have an enforcement statute come into play. That's what I'm working on. I'm working on getting the enforcement element done, because if we can show that there was criminal acts were committed because people broke the law, then it's going to clear up the obstruction for all of you to be able to seek your civil injunction and move forward with all these civil rights cases that you guys are trying to do. But attorneys don't understand what I do, right? They want to go with litigation. They're telling you, yeah, let's sue. But they don't understand why nobody wins these lawsuits. They don't win these lawsuits because before you can sue, you must first show that someone had a duty to act and they breached that duty. You do that through the enforcement statute. That's why I'm coming forward trying to get all these people held accountable for the crimes that they committed in the violation of the law. Because if I can do that, if I can show that they had a duty to act and they breached that duty, I can show that that's a crime. And by that crime, now that will give rise to all of you to seek your injunctive relief, to be able to sue and be able to be made whole, whatever that might be. I don't deal with that side. I don't care about that side. That's what attorneys do. They like to do that. I enforce the law. So I'm working on this side over here, you guys. That's why a lot of people are confused about me, is that they want me to help with a civil rights lawsuit, and I don't do that, because before you can sue for a civil rights lawsuit, you must first show that there was a criminal violation. You have to show the criminal violation. This is what happens, right? This is the catch-22 that everybody finds themselves in. They want to sue, right? And they deserve to. You all deserve to be made whole again for the crimes that have been committed against you, for the breach of civil rights. I wouldn't disagree with that at all. But there are steps that have to be followed. Okay, so you can't sue the agent because they have immunity, right? You have absolute immunity, you have civil immunity or judicial immunity, you have prosecutorial immunity. That immunity applies to civil liability, meaning that you don't sue the agent, right? Because the agent is only performing mechanical duties on behalf of the master, right? He's only doing what the master told him to do. So you don't sue the agent, you would sue the master who told him to do it, right? So in other words, you would sue the state who told the judge to do what I want. But you can't hold the state criminally liable because you can't put a state into jail. So you have to hold the agent criminally liable, and in doing so, then you can hold the master civilly liable. But what happens is that the system knows this. The system knows that if we hold our agents criminally liable for the crimes that they committed, because they're crimes, right? Deprivation of rights and color of law is a crime. It's a crime that's actually punishable by death. That's prescribed by law. It's a serious offense, you guys, right? So, but they don't want to hold their agents criminally liable because they know if they do, then they're prescribed by law. It's a serious offense, you guys, right? So, but they don't want to hold their agents criminally liable because they know if they do, then they're going to be sued. Someone just tried to call in, butt in. You guys still hear me? Give me a thumbs up if you can, because sometimes that cuts it out. Can you guys hear me? I'm going to assume those hearts are a yes. Okay. So that's the problem is that most people, they want to sue first. But before you can sue, you must first hold the agents criminally liable. Once you hold the agents criminally liable, that gives rise to the injunctive relief. That's the moment that you're able to sue. But if rights derive from another's duty to act, then that means that you cannot have a right violated until you first show that someone else had a duty and they breached that duty. And that comes from a law. So if the law states that no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, and then a judge in the state of Washington says, I'm going to hold this person over without an indictment by a grand jury, and then a judge in the state of Washington says, I'm going to hold this person over without an indictment by a grand jury, that judge person over without an indictment by a grand jury, that judge rights to the club law, right? That's what he did. There's no denying that that was a crime that he just committed. And as a result of that crime, guess what? Now nothing that happens after that, nothing is valid anymore. Nothing is valid. Because by the judge's criminal act, the breach of constitutional obligation, everything that the court produces from that moment forward must be unconstitutional because it all derives from an unconstitutional act. But they don't want to hold that judge criminally liable because they know that if they do, everything is a wash. Everything is void. Nothing matters anymore, right? And they also know that if they hold the judge liable, then you can sue the state for the damages that the judge caused. So you got to understand there's steps that are necessary here. So I'm trying to get this first step done. I deal with criminal matters. That's what I do. I don't deal with the litigation of suing and being made whole. That's something that I want to free up the obstruction for you. I want to hold these guys criminally liable for the crimes that they've been committing for 243 years. That's what I want to do. I want to hold this government accountable for the crimes that they commit every single day against all of you. That's what I'm trying to do. And that's why I'm focused on a criminal affidavit from all of you, because when you provide evidence of a crime that's been committed against you in the form of a written testimony, right, they can't refute it, right? So the affidavits that we have, they're very, very simple. And we want them to be simple because just like I was saying on a conference call earlier today, that we don't want to, we want to group as many people together. Remember, we have 7 million people that have been charged with or convicted of a crime unlawfully by this system, right? Every single one of them can all talk about the same issue, and that is that they were charged unlawfully, right? By not having an indictment by a grand jury, right? Or by charge by information. Every one of them, except for about 1% of them, can say that because only about 1% actually were present in the grand jury to be able to confront the accusations against them. So every single one of them are able to say, "Hey, this happened to me." And so what happens is that most all of you, you call me up and you say, "Hey, that my evidence is being suppressed, or the judge lied, or the officer lied." You're telling me all these things, but these things are after the moment that the state broke the law, right? It's the moment after they didn't have authority to even be able to oversee the case because the judge didn't have the proper documentation in place. Why are we talking about those things? Because the system wants you to talk about those. Those are diversions, you guys. Those are getting you to spend your time talking about something that doesn't even matter. Because if the state didn't have the authority to do anything because the judge didn't follow the rules, then all those things you're talking about, all the energy that you're spending pushing on trying to get attention on this, none of that matters. And the state loves that. Because the more you talk about things that don't matter, the less you're talking about the crimes that they committed against you. So if we can all swing back and say, you know what? We'll have an opportunity to talk about all this stuff. What happened to you, the suppression of evidence, the judge, what he said, what he did, what the prosecutor withheld, how the prosecutor threatened you, all of that will become important when you go into injunctive relief, right? When you go into the next phase. But this first phase, we need to deal with the criminality. So all of us, 70 million people can talk about the same thing, and that is the state didn't have authority to do it. because the state brought an accusation against me. That judge was supposed to recuse himself, and he didn't recuse himself. And as a result, we can talk about the exact same. We can get 70 million people talking about that, focusing all of their energy on that. And when we do, it's done, right? Because they want to have you creating this diversion. They want you talking about something that's well beyond the moment they committed a crime. If we stop focusing energy on all the things that don't matter, and we instead focus on talking about the crime that they committed against you, then we have 70 million people talking about the same thing. Now we know which direction to look. Now they won't be able to overcome it, and they won't be able to stop it. So you have a story to tell. You all do. And you deserve to tell that story, and you will get the opportunity to tell that story. But what we need right now is we need something that's going to shock the public to wake the fuck up, right? That's what we need right now. That's why the next 13 days is so important, right? Is because I need to get these affidavits from all of you. I need to get around this country. I want 500,000 criminal affidavits from all of you. And if I get more, that's great. That's wonderful. But I want 500,000 because I want to make sure that when I get that before anybody walks into a voting booth, right, to vote on November 5th, I want to make sure that they know exactly the criminals that they're voting for. So if they have the information and tools that they need to make a decision, do I want a criminal in office any longer, right? And if you don't, then awesome. Let's go ahead and write in someone that you do want or that you do trust, right? I do not want anybody to go in there unaware of the situation, because the majority of the public, they still believe in this system being good, right? If you're not directly impacted by the system, then you believe that it's good. You believe, oh, judges, they're good, right? Look, they're honorable. They do all the honorable stuff. Prosecutors are honorable. They do all the, they're just cleaning up all the garbage from the streets and locking all the bad people up. People don't understand that they are not good. They're criminals, right? And if they want to act criminally because they don't want to follow the law, then we're going to call them out for what they are. And we definitely do not want people walking into a voting booth believing that criminals are good. That's why we got to bring this information forward. I got to get this information back to DC before the election. And so, some people were asking me questions this morning about, okay, what's the objective here? What are we going to get out of this? Guys, we're not going to get resolution. I'm not planning on going back to DC and have all this settled all of a sudden. I'm not expecting that all this will all be done and taken care of. What I am expecting is that we're going to get enough attention to this issue that we're going to wake the public up, because we have the power of the election cycle. If these public officials, if they want to get reelected, if we can get this into public domain, if I can bring a truckload of affidavits from all across the country in every state, from all of you, from the crimes that have been committed against you, if I can bring that back to DC, do you think that's going to make the news? Yeah, I think so. I think we're going to be all right. And if we make the news, then the question is going to be to these public officials, well, hey, what's going on? Why aren't we following the Constitution? And then those public officials, senators, congressmen, whoever they are, they're going to say, well, you know what? Yeah, we got to follow the Constitution. Because if they don't say that, then guess what? You ain't getting elected for shit. Tell the American people you're not going to follow the Constitution. They're praying that this doesn't come out. They're praying that I'm not going to be successful here, and that they'll be able to get reelected without this coming forward, because they're hoping and praying that all of this will be able to go under the rug, that they'll be able to go about their business and pretend like nothing happened, whatever. But we cannot let that happen. We need to use this election cycle right now to get the power to force their hand, right? We're not going to get the resolution by November 5th, but what we are going to do is we're going to wake the public up. And once the public is woken up, then we can start a discussion. Then we can start talking about it, okay? We can start talking about the issue, and we can start working to resolve the issue. But we've got to wake them up. So this is the affidavit, right? Now, this is going to be released. What we're waiting on right now is I still need a vehicle. I still need a way to get around the country. And so we're not going to release this until I have the ability to do it, right? I am in a safe place right now, and I'll be here until I'm able to get on the road. We need help from all of you. I need help from all of you. I need help, right? I need to be able to make this happen, and you guys are the only way that we're going to be able to do it, right? I don't have the funding to be able to make this happen. I don't have it. I put every single cent into everything that I've got. I put into this, and I don't have any more. So we need the help from all of you, and every single dollar counts. I've got 7,000 followers here. I've got another 7,000 over on Facebook. If everybody gave $1, that would probably be enough to be able to get us around the country. That would probably be enough, right? $1. If every prisoner, right? If every prisoner recognized the fact that hey, I'm doing this to help all of you. If they each gave up one ramen pack, $1, and sent it to me, that would be 2.9 million. That would be enough that not only would we be done, but we'd have billboards in every single state, put up. We could make this happen. It doesn't require much. We have 13 days. 13 days is all I need to do. I need to get into a vehicle. I need to have that vehicle running nonstop, driving around this country. We need to have we're working with a couple of groups such as the Veterans of Foreign Wars, VFW, right? And the VFWs will become repositories. So once we get the affidavits released, once we have the vehicle and the means to get around the country to pick these up, we will release the affidavit. It's a very, very simple form, and it has an instruction form with it. You guys are going to fill it out, and then you're going to take it to your closest VFW, right? And you'll give it to the VFW. Now, I need 500,000 of these that are going to be transferred hand over, where we have control and custody of it. If you don't have a local VFW, if you aren't around one, then we will accept it in the mail. But I have to have 500,000 where we actually get a handoff in full custody of it. But if we can get another 2 million on top of that, well, great, that's gravy. But we need 500,000 that's in full custody, that's gonna be handed off. So there's VFWs all across the country, and they all have veterans. The veterans are gonna self-execute their oath. They'll be acting in the law enforcement capacity to be able to receive these affidavits. And then what I'm doing is I'm gonna be driving around the country to each of these major cities, picking them up. We won't turn that car off until we get back to Washington, D.C. on November 4th. And once again, this is a matter of I'm going to be doing the lives every day. I'm going to be doing radio interviews every day. I'm going to be doing podcasts every day. We're going to be doing everything we can to get this information out so that when we do get back to DC with a semi-truckload of affidavits on behalf of all of you for the crimes that have been committed against you, then that's going to be something that's going to be noteworthy, right? That's going to be something that's going to be that they're going to want to talk about. And so once we get there, once again, the hope is that we can get their attention. We need the public to become aware of the true reality of what they call good, because what they call good is not good. That's not good, because they're out killing people with absolute impunity. They're out violating your rights and breaking the law every single day, and yet they say, "Oh, the law doesn't apply to us. We're above it." No, you're a servant to us. We created the law. You're bound by that, and we're going to hold you accountable for the crimes that you commit. And so, this is a huge endeavor, right? It's a big task, but if we don't do something about this, you guys, we don't do something about this government, I don't believe we're going to make it 4 more years. This isn't about parties. This is about a systemic, breach of the very laws that create the government, where they're refusing to even recognize, their obligations. They're doing whatever they want to do, and they're destroying the country. And then they have the majority public actually convinced that they're the good guys. I mean, they're not. We've shown that they're criminals. We've shown that they're refusing to recognize and enforce the body of laws of the government of the nation. I mean, 33 states, we've taken it to the highest law enforcement officer and the highest judicial officer, given them months to be able to act in a lawful manner, and yet completely quiet, crickets, continuing to do business as normal, continuing to act in a treasonous manner in violation of the very laws that create their office and grant them authority. We cannot permit this to continue any longer, you guys. We can't. And so, again, I don't have a lot of time. I'm here, and I was hoping to be able to get a little bit further along on all of this than we did today. But I need help from all of you. We need the donations, and we need them quick. If you guys ever wanted to get behind and help out in something, this is as good as it gets. I mean, what better place to invest than in the preservation of the country by holding those accountable for destroying our country, accountable for the crimes they commit. I will do the things that I say that I'll do. I've been consistently doing what I said that I would do. I've gone around the country and I've delivered the affidavits on behalf of people. I've served the Attorney General. I went back and I served the Supreme Courts. I did it in the period of time that I said I would do it. Every single cent that you guys have given me, every single time has always accomplished the things that I said that I would accomplish every single time. And I'm asking you guys one more time, you need to put your faith in this, right? We can do this. We can use this election cycle and we can use it as an opportunity to force their hand into making them actually do what they're lawfully obligated to do. But we have to create noise. We have to make it happen. And so, you know, if you guys are willing, if you guys can, please, you know, please send what you can to us. Please send over whatever donations you can. Every single dollar is going to count right now. We have Chime, we have Venmo, we have PayPal, and we have Cash App. They're all exactly the same. It's We Shall Be Free. That's WESHALLBEFREE. We Shall Be Free. And remember, there's reasons why I have those particular ones. I don't have Zelle because I don't have an address, you guys. I can't have an address. That creates a contract with the state. I can't have it. So I'm not a grifter out here. I don't have this because, because I'm a dirtbag. I have these for a very specific reason, and that's because I can't have state contracts, you guys. I can't have a state ID because that would create a contract. Right? I'm doing these things because this is the legal strategy we have to be able to overcome this issue, right? And a lot of people would say, oh, well, Cash App is what, guys, I don't have to have an address to have Cash App. I don't have to have an address to have PayPal, right? Those are the reasons why I have it. It's not because I'm a grifter. It's because I have a strategy and we're living those strategies. All of you that know about state nationals, all of you that know about them, you guys know that you can't have an address. You guys know that you can't have a state ID. Those things I can't have. The only ID I carry is my VA ID, a federally issued ID, and it's good for travel. That's the only ID I have. I don't carry anything else. I have no addresses. So, so if you guys can, please, we need the donations. We need them bad right now. We need them bad. I needed to really be on the road tomorrow, but if I don't have a vehicle, I'm limited. I can't do anything, you guys. So where I'm at right now, I'm good. I'm safe, but I need to be on the road as soon as possible because we don't have a whole lot of time. So I'm going to read you guys the affidavit here, okay? This affidavit is going to be the exact same form. This is what's going to be released, okay? We're going to have this out on Google Docs. We're going to have it out on OneDrive. We're going to have it out on SharePoint. We're going to have it on 3 different websites, okay? So it's going to be readily available to all of you the moment that I'm ready to leave, the moment that I'm ready to pick these up, because we don't want to go early, you guys. We don't want to go early. But the moment that I'm able to get out and start picking these up across the country is the moment that we're going to release these. And then once released, right, just as I said, you guys, they need to go into someone's custody. They need to go into someone that's authorized to be able to receive them. That's why we're going to use the BFW, the BPOE, these other organizations that already have the infrastructure in place that works with veterans. And you guys are going to go in there. You're going to hand it off to them, and they're going to take custody of it, right? And then they're going to meet me in a central location, and I'll drive through. We'll pick them up, and we'll drive them back to Washington, D.C. And if you guys want to be there on November 5th, you want to help carry a box in with us, great. Then meet us there because that's what we're going to do this time. Okay. So again, we do not want to add anything to these affidavits. We want them to be exactly the same because this creates the class action. So as long as we're all talking about the same issue, as long as we're all pointing at the same problem, then that creates a class action, a class group, right? If you guys add anything to this, if you guys start talking about how evidence was suppressed in your case, then that's going to remove you from within the class. So that's why I've made this affidavit so simple that all 70 million people who are going through a criminal matter are all going to be able to be a part of it. And in one moment, I'm going to tell you about the family side of it. Okay, I'm going to tell you how we're wrapping the family in. So the undersigned of lawful age does swear and state the following facts: A, on or about, place of date, a person portraying themselves as prosecuting attorney for X county, state of X, in their official capacity, did deprive you, victim, of rights secured by and enumerated in the Constitution of the United States of America when they charged the victim for an infamous crime by information, not by indictment, from a grand jury as required by Clause 1 of Amendment 5. Simple. That's deprivation of rights. They charge you by information, right? The prosecuting attorney or a person portraying themselves as a prosecuting attorney, did deprive you, victim, of the rights. So now a crime was committed against you. You don't need to add anything else to that. By that crime alone, that voids and negates all of everything else that the court does from that moment forward, because that was an unconstitutional act. And you don't need to add anything else to it. That creates the crime. So Part B, on or about X, a person portraying themselves as a judicial officer for X county, state of X, did in their official capacity conspire by and between person portraying themselves as a prosecuting attorney in their official capacity, person portraying themselves as a law enforcement officer in their official capacity, to deprive you, victim, of rights secured by and enumerated in the Constitution for the United States of America, when the victim was held to answer for an infamous crime by information and not by indictment from a grand jury as required of Clause 1 of Amendment 5 to the Constitution for the United States of America. That's simple. That established the conspiracy, because the moment that the judge relied upon the incorrect charge instrument because the base crime was committed by the prosecutor, that's the conspiracy, right? So that's done. You were held to answer now because the officer who made the arrest, the prosecuting attorney, and the judge conspired to deprive you of rights enumerated in the Constitution for the United States of America. You don't need to add anything else to it. That's as simple as it has to be. You don't need to add anything else to it, okay? So these acts are against the peace and dignity of the United States of America by agents of states that are subjected to the jurisdiction thereof. States are subjected to the jurisdiction thereof, and the agents are as well. Wherefore, affiant prays that this information be investigated and found to be true and correct, and that a true bill be issued for the arrest of the within named defendants, and that he, she, they may be brought before a magistrate and held for the offenses of 1. Deprivation of rights under color of law, Title 18, subsection 242. 2. Conspiracy to deprive rights, Title 18, subsection 241. 3. Kidnapping, Title 18, subsection 1201. And 4. Any other crimes is ascertainable by the evidence on the record. There's no denying those crimes. None. Deprivation of rights under color of law did occur when they deprived you of a right guaranteed and enumerated in the Constitution of the United States of America. Okay? The conspiracy of rights did occur when the judge chose to hold you over without having the proper charge and instrument in place. There's no denying that. And then the kidnapping charge, it is a federal offense, and it's important that it's a federal offense, but it's a federal offense because in order for a federal kidnapping to occur, you must be held over for ransom. And you were, in the form of bail. So when they held you over for ransom until you paid them $700 or $7,000, or your family paid for your release, right, for the release of the kidnapped, that is kidnapping, you guys. It's a federal kidnapping offense because they said, oh, yeah, we took your loved one, but unless you give us your car title or unless you give us your house title, we're not going to release your loved one. Doesn't sound much more. I mean, we may as well be down in Colombia amongst the cartels, you guys, because that's what they're doing. I mean, there's no denying any of this, okay? So then I do verify under the penalty of perjury and the laws of the United States that the foregoing is true and correct, and that the infamous crimes above mentioned did occur in my presence, and that I'm empowered to enforce and defend the laws of the United States as a person subjected to the supreme authority of the Constitution for the United States of America. What you're doing here is you're saying that this is a citizen's arrest, right? It was a felony committed in your presence. And under the laws of the United States, every single person within the United States has the authority to enforce the laws of the United States by issuing an order for arrest if it was a felony committed in your presence. Remember, you're not ordering this under state authority. You're ordering this under your federal authority. Because under the laws of the United States, every person has the authority to order an arrest for anybody that commits a felony in their presence. Okay? And when you were arrested and held over for an offense, that was a felony, and it did occur in your presence. Therefore, you can order an arrest under federal law authority. Simple. Okay? Now, the other thing, going back to the beginning, I said that when you deal with the Fourth Amendment, it says that no warrant shall be issued but upon probable cause supported by oath or affirmation. Well, the problem with what the states are doing is that they're relying upon an officer who was not a witness to the crime to issue the oath, right? So the officer is coming in and saying, "Oh, this information is truthful, factual, and correct based upon my oath." Well, we don't give a shit about your oath, officer, because you weren't a witness. But what I'm doing is I'm bringing in the actual witnesses. You guys are the witnesses. So these are valid orders for arrest under the Fourth Amendment because you guys are swearing under penalty of perjury of the laws of the United States that this information is factual, truthful, and correct because you swear the oath, because you are swearing it's factual. We are doing it lawfully. This is the lawful way. I'm not saying that I'm receiving it and I'm signing it saying, yeah, I was told that this is true and my oath it supports this. No, I'm going to you. And you're swearing by oath, by penalty of perjury, that this is factual, truthful, and correct, which means that these are valid Amendment 4 warrants, not what the states have been doing. The states have been violating the Fourth Amendment because the oath was meant to come from the person accusing of the crime, the witness, and it didn't happen. Okay? So this affidavit is sworn to be true and correct, and it has full force and effect of law, does not need to be verified by a notary public. It does not need to be notarized by a notary public because the states the officers do not notarize their criminal informations, right? And when they don't notarize their criminal informations, then when they don't notarize their criminal informations, then that means we don't either. And if they want to say that we were supposed to notarize ours, then I'm going to be able to say to them, okay, why didn't you notarize yours? Because if we have notarized ours, then that means that yours are all invalid as well. So we're simply mirroring what they're already doing in order to be able to destroy their arguments. If we're doing it wrong, we're doing the same thing that they were doing. We're setting up and acting the same way. So if they don't notarize their criminal information coming from the officers, we're not doing the same thing that they were doing. We're setting up and acting the same way. So if they don't notarize their criminal information coming from the officers, we're not going to notarize ours either. Okay? We don't want to do that. So that's the reason why we're not doing it is because we want to defeat their argument. We want to do the same thing that they do. We want to mirror them, and in mirroring them, then we can say, okay, if they want to accuse us of doing something wrong, then we can simply say, okay, well, we're just doing what you did. Therefore, if we're wrong, you're wrong too. Okay, it's going to illustrate their criminality by being able to do it that way. So those are the affidavits wrong too. Okay, it's going to illustrate their criminality by being able to do it that way. So those are the affidavits. The forms are going to be very, very simple. The forms are going to be very, very simple. They'll be released again as soon as we have the ability to be able to start traveling across this country. Again, 13 days, guys. I need help. I need help to make this happen. But I've done everything that I said that I would do from beginning to end. Okay, the last 6 months I've been across this country. I've driven 44,000 miles in the last couple months. Just serving the attorney generals and serving the Supreme Courts. You guys, I will do what I say that I'll do. Okay, you guys can put your faith behind this. Put your faith behind me, and you know what? The fact that I'm still walking, the fact that I'm not 6 feet under, that should tell you guys an awful lot about what I'm doing here. Because I'm able to say these things about our government, and yet I'm still walking around. I'm still serving them, right? They know exactly where I'm at. They knew where I was at, the day that I gave them a deadline. So you guys, I'm not worried about what they can do to me, okay? You guys don't need to worry about what they can do to me. What we need to worry about is the future of our country, okay? So now let's do to me, okay? You guys don't need to worry about what they can do to me. What we need to worry about is the future of our country, okay? So now let's bring in the family element to this, okay? So when it comes to the affidavits, we can do this for CPS and family matters as well. Because just like the indictment issue, the indictment is what we're using to get in because it's a facial constitutional violation. Anybody can open up the Constitution, can go to Clause 1 of Amendment 5, and they can see, oh yeah, you have the right to indictment by a grand jury. Did I get one? No. Awesome. That's a facial constitutional violation. Now the CPS issue is just a little bit trickier because the right to have an intimate familial relationship with your child, that was bound to exist within the First Amendment. It's not actually written in the Constitution. Nowhere in the Constitution does it say that you have the right to have a relationship with your child. Now we know that you do, and my argument is that protecting the family unit, that should have been the first duty of our fucking government, not the last, right? The fact that we're now having to fight to protect our family now, that should have been what Thomas Jefferson and George Washington did from the very beginning. But they failed us because they wanted to protect their property instead. And so now we're having to protect our family as the last action of this government, not the first, right? That should have been the first. But nonetheless, we're now having to protect our family. But nowhere in the Constitution does it say that you have the right. But it was found to exist under the First Amendment, which is important because now it becomes part of the Constitution because it's already been incorporated. The Supreme Court has already said you have the right to have an intimate relationship with your child. So the affidavits that we're going to get from all of you on the CPS issue, it's basically going to say that on such and such date, this person did deprive me of my right to have an intimate familial relationship with my child when they removed the child from my presence. So the wording's only going to change just very, very ever so slightly, but it still is the same thing because an agent of the state did deprive you, victim of rights guaranteed by the Constitution, when they removed your child from your custody, when they interfered with your relationship with your child. That's deprivation of rights under the code of law. That's the first part. Now, the second part is on such and such date, this judge did conspire by and between this agent who removed my child to deprive you of victims guaranteed by the Constitution when they remove the child from your presence in violation of Amendment 1 to the United States Constitution. That establishes the conspiracy. So now we have the exact same scenario, right? That's as simple as that right there. And we would go through the exact same thing. So another thing is if you don't know the judge's name, that's going to be okay, right? Because when you think about when you go and you file like a criminal report, someone comes and robs your house. Do you know who did it? No, somebody robbed my house. So the criminal report says, oh yeah, somebody portraying himself as a robber came in and stole stuff from the house. Lots of times we don't know who the offender is. So all we can say is, yeah, it was some man, 5'5", appeared to be white and wearing, a black jogging outfit. That's all we know. So, if you don't know the name of the judge, hey, sometimes we don't know who our offender is. If you don't know the name of the prosecutor, you don't know the name of the CPS agent that stole your child, if you don't know those things, that's okay. Because we can still say person portraying themselves as a CPS agent for the state of whatever, right? Or person portraying themselves as a judicial officer for the state of whatever. Person portraying themselves as a prosecutor. We can still say because we don't have to know who they are. That's not they committed a crime. Someone did do it that was portraying themselves as a state agent, right? And that's sufficient. That's sufficient to be able to do these affidavits. So we're going to want all of the parents who have had their children stolen. Now, bear in mind that every one of these affidavits, every single person has this right. So when you have a mother and a father who had their child removed, we can get 2 affidavits from the mother and the father. Now, if you had 2 children that were removed, now we can get 4 affidavits, right? Because one for this child, one for this child, one for the mother, these numbers will go up astronomically. Very, very quickly, we can take these numbers. Now, you can also say that your child had the right, right? Your child had the right to be a child. He had the right to intimate association as well. Therefore, a crime was committed when your child was removed and his rights were removed and that did occur in your presence because not only was the child taken from you, but you were taken from the child, which means that the felony that occurred on behalf of your child, you can sign for that as well and order the arrest for that. So now, if you have 2 children taken, now you can have a mother and a father that can accuse for the child being removed from the family, but then you can also have mother and father, accused for the rights that were taken from them. And now we've got 8 from one family, right? But now we got to get into collateral damages, right? Now we got to get into collateral damages because what about that mother or that grandma and grandpa, right? Where were their rights? When did someone come in and say that they don't have, that they're no longer fit to be a mother or a grandmother or a grandfather, right? So the state came in and removed their right to have an intimate relationship with this grandchild without any due process whatsoever, right? The state didn't say, oh, well, grandma, grandpa, you guys aren't really fit to be a grandma and grandpa, so we're going to take this child away. No. The state came in and said, okay, mom and dad, you guys aren't fit, so we're going to go after you. But in doing so, we're going to automatically, through administrative TPR, we're going to terminate the rights of the aunt, the uncle, the cousin, the brothers, the sisters, the grandmas, the grandpas. All of those people have a right to have an intimate relationship with that child because that's all part of the familial unit. So now we got a whole lot more people now that can come into play, right? Because everybody who has had a right taken from the state, who removed a child from them, They never had any hearing to determine that they were unfit to be a grandma or grandpa, or they were unfit to be an aunt or an uncle, or they were unfit to be a cousin or a brother or sister. All of those are rights that are protected by the First Amendment's familial unit. And every single one of them had a crime was committed against them. Grandma, grandpa, aunt, uncle, cousin, brother, sister, every single one of them can file a criminal affidavit against the state for depriving them of a right to intimate association with that child. Every one of them. Because there was never a hearing. They never had an opportunity to be able to say, oh, no, I want to have this relationship with him. Now, there's item number one. Item number two is that every single prisoner that goes to prison, that's someone's husband, right? That's someone's wife. That's someone's son or daughter, right? So when they took that person and they put him into prison, have they not interfered with your intimate association with your wife or your son, your daughter, your mother? All of you, right? The family members of those that are in prison, all of you also had a right to have an intimate association with that person in prison. You had that right. And when the government came and interfered with your right to have a relationship with that prisoner, right? Interfered with your marriage, right? Without due process, you can say, oh yeah, I had a right to have a relationship with my husband without governmental interference. And guess what? Government has interfered with that relationship. Now your wife can file one of these, right? Not just the prisoner, but the wife can. And then mom can too, because mom says, well, you know what? I don't get to communicate with my son anymore because government came in and interfered with my relationship, right? That would be a deprivation of rights in a color of law. That would be a violation of the First Amendment's intimate association. So if you guys can see now, these numbers can go up astronomically. We can take this from 500,000 to 200 million in no time. Guys, what we have here, what we're doing right now, this is going to be the biggest class action lawsuit in American history, period, hands down. This is going to make Brown versus Board of Education look like small claims court, you guys, because this affects so many people, because every prisoner, has mothers and fathers, has wives and brothers and sisters. Every one of them had their relationship interfered with by government. Now, whether it's valid or not, whether you believe that person should be in prison or not, that's not what we're arguing. What we're arguing is that if we have constitutional rights, then government, you can't interfere with those. That's all we're trying to do, I'm not saying anything other than this is what the Constitution says, therefore this is what government's restrained. You guys exceeded your restraint. So we can come forward with a whole lot of these really, really quickly. And that's what we need to do. That's what I need help from all of you. I need to get this vehicle so we can get on the road. And as soon as I'm ready to get on the road, we're going to release these affidavits. We're going to release them out to the sites. We're going to get all the information for all of you. And I know without a doubt in my mind that you guys are going to share the ever-loving shit out of this, right? You guys are going to put it out there. It's going to go viral. And we're going to have that 500,000 affidavits within 2 days, right? 2 days. And then after that, I'm gonna go back to DC, and we're gonna be showing up in DC with a semi-truck load of boxes and boxes and boxes of evidence against these assholes that are attempting to be reelected. And we're gonna have an opportunity to be able to say to the American people, hey, guess what? Every single state, all of these people, what do you want to do about it, public officials? And those people that are up for reelection, right? Those people that are trying to get elected, they're gonna have to say, you know what? You're right. We're gonna have to get behind this. And then we get the country talking about it. So we're trying to create something that's going to be so shocking that we can finally wake the people up, right? And that's why I need your help, right? I need your help. So this is what I do. I do the criminal stuff. I don't do the injunctive relief. I want you guys to save your money. Don't go to these asshole attorneys. Don't rely upon these criminals. Let me free up the obstruction, and then something tells me that it's probably going to be easy enough at that point in time for you guys to be able to file your own paperwork. Keep your money. Don't give it to these assholes, right? Don't proliferate their industry anymore. Give me just a little bit of time. Put your faith in me. Let me handle the criminal elements of dealing with the violation of the law. And when we do, I think you guys will be able to handle your own litigation. You guys won't need an attorney to do that because we don't need criminals to be any richer. Okay. So you guys, thank you so much. Thank you for listening. Looks like we had a pretty decent turnout. We were at 150 most of the show. So So I appreciate you guys so much. And again, if you guys can support, you guys can donate. We could really use the support right now. And every single dollar is so essential. I mean, it will be used. This money is not going to anything other than to overcome this issue, you guys. All right. And once we get a vehicle, if we can get into a bus, that would be awesome. If we can get into a truck, that would be awesome. But we need something that's going to be able to haul all this paperwork around, and that vehicle is not going to be turned off between now and the time I get back to DC. We won't be staying in hotels. I'll be sleeping in whatever. Guys, I'm doing this for all of you because we need to save this country, right? So if you guys can support, we have Cash App, we have Chime, we have Venmo, we have PayPal. They're all exactly the same. We shall be free. That's WESHALLBEFREE. You guys, this is the last one right now. This is the last one, okay? So this is the last trip around the country, and I feel it in my heart that this is going down now. All right, and just give me the opportunity to do one more trip here. Let me give you the opportunity to circle this country. And the moment that we have a vehicle, I mean, maybe some of you guys got a bus or access to it. I don't know. Whatever you guys can do to help. What we're looking for is something to get in and get us around this country, and hopefully with enough room that any one of you that want to jump in and help out. The more the merrier. We have rallies that are being set up for me in Atlanta. We have rallies that are being set up for me in St. Louis. There's going to be at least a couple other cities, I believe Chicago and Houston. Guys, we're going to be out there, and the next 13 days is critical. It's critical to bring all of the knowledge of the crimes committed against you forward so that we can hold these assholes accountable, or we can force their hand into actually doing what they're lawfully obligated to do, all right? So thank you guys so much. And continue to follow me. Please share. Let's get these algorithms back up. I'll give you dates and times on the rallies. The only date we have so far is the Atlanta rally. Senator Arnold is putting that on for me. We have another one in St. Louis that they're planning on setting up. All of these are going to be within the next 2 weeks, right? So I know Houston, there's a group there that's talking about setting up a rally for me. Chicago is talking about setting up a rally. Atlanta's already scheduled, and in St. Louis, and there's going to be some more. But just so that you guys know, this vehicle is not going to be turned off. I will not stop between now and the time I get back to DC, and I hope to see y'all there, because we're going to be coming in town with an awful lot of very, very damning evidence against these guys. And they can either tell the American people that we're not going to follow the Constitution, or they can say, well, looks like they got us now. We gotta follow the law. We gotta do, because they're scared of the public. They're scared of the public actually finding out the truth about the criminality. We're going to bring that forward, and they can either step forward and act lawfully, or before anybody walks in that booth, I want them to know that these guys are criminals, and we don't want to see criminals voting. So, all right, guys, love you. Thank you so much. Continue to follow me. Please share the video, and together we shall be free. Thank you so much.